Hello. Today we are discussing the judgment in Criminal Appeal number 1609 of 2011, in which the appellant is Manikandan and the respondent is State of Tamil Nadu by the Inspector of Police with another Criminal Appeal number 407 of 2019. Before analyzing the judgment, the golden thread which runs through the web of administration of justice in criminal cases is that if two views are possible on the evidence adduced in a case, one pointing to the guilt of the accused and the other to his innocence, the view favorable to the accused should be adopted. This is to be kept in mind in criminal cases, and we are continuing the discussion. The appellant in Criminal Appeal number 407 of 2019 is the accused number 1, and appellant in Criminal Appeal number 1609 of 2011 is the accused number 2. The trial court convicted both the appellants for an offence punishable under section 302 read with section 34 of the Indian Penal Code 1860. By the impugned judgment, the High Court has confirmed the conviction and life sentence of the appellants. We are referring to the prosecution case in brief. We means the Honorable Judges of Supreme Court of India are referring to the prosecution case in brief. The name of the deceased is Balamurugan. He was staying with his parents. PW1, PW എന്ന് പറഞ്ഞു കഴിഞ്ഞാൽ prosecution witness 1, Mahalingam, and PW2 Veeramal. According to the prosecution case, the deceased had instructed accused number 1 to deliver idlis at his home. On 4th October 2007, at about 9 p.m., the deceased came home and inquired with his mother, PW2, whether accused number 1 had delivered the idlis. On learning that accused number 1 had not delivered the idlis, he immediately went out and reached the house of accused number 1. It appears that there was a commotion, Bagalam, commotion means Bagalam, to his altercation, Tarkam, with the accused number 1. According to the prosecution case, after hearing the commotion, PW2 and PW3, the brother-in-law of the deceased, rushed to the spot. Accused number 2 was present at the spot. After that, accused number 1 entered his house, brought with him a bill hook. What is bill hook? Vakati, Koduvala, bill hook, and assaulted the deceased with the bill hook. Where the first blow fell on the right index finger of the deceased. Thereafter, the deceased ran away to the nearby garden of one Karunanidhi. The accused followed him. The accused number 2 held the deceased, and accused number 1 assaulted the deceased with the bill hook on his neck. Both the accused fled after that. അവിടുന്ന് ഓടിപ്പോയി രണ്ടുപേരും accused. According to the prosecution case, PW2, PW3, PW4, that is sister of PW1, and PW5, son of PW4, witnessed the incident. Submissions. We are discussing the submission of land council appearing for the appellant. The land council appearing for the appellant pointed out that the FIR, that is first information report, shows that the incident occurred at 10:30 p.m. However, from the approximate time of death mentioned in the postmortem notes, it appears that the incident must have happened before 7 p.m. ഫസ്റ്റ് ഇൻഫർമേഷൻ റിപ്പോർട്ടിലെ വിവരങ്ങളനുസരിച്ച് 10:30 ഈ സംഭവം നടന്നത്. എന്നാൽ പോസ്റ്റ്മോർട്ടം നോട്ടിൽ 7 PM മുമ്പ് തന്നെ ഈ സംഭവം നടന്നിരിക്കാം എന്നാണ് പറയുന്നത്. His second submission is that though other independent eyewitnesses were available, the prosecution had chosen to examine only the witnesses closely related to deceased who were interested and tutored witnesses. ആ സ്ഥലത്ത് സ്വതന്ത്രമായ ദൃക്സാക്ഷികൾ ഉണ്ടായിരുന്നിട്ടും പ്രോസിക്യൂഷൻ മരിച്ച ആളുടെ ക്ലോസ് റിലേറ്റീവ്സിനെ മാത്രമാണ് സാക്ഷികളാക്കിയത്. അതും ട്യൂട്ടേഡ് വിറ്റ്നസ് ആയിരുന്നു. Therefore, their testimony deserves to be discarded. അവരുടെ സാക്ഷ്യം ടെസ്റ്റിമണി തള്ളിക്കളയണമെന്നാണ് കൗൺസിൽ ഫോർ ദി അപ്പലന്റ് പറയുന്നത്. വിത്തൗട്ട് പ്രിജുഡിസ് his further submission is that, very important, it was the deceased who went to the house of the accused number 1 to inquire about the failure of accused number 1 to deliver idlis at his home. The fight started only because the deceased went to the house of accused number 1. ഈ ഫൈറ്റ് ഉണ്ടായത് എന്താണ്? ഡിസീസ്ഡ് ആണ് അക്യൂസ്ഡ് നമ്പർ 1 വീട്ടിലേക്ക് പോയത്. He submitted that post-mortem notes show that the deceased sustained one cut injury on his neck, and one minor injury to his finger. Not this point. He further submitted that there was a sudden fight between the deceased and the accused number 1, and in their sudden fight, without any premeditation, മുൻകൂട്ടി തീരുമാനിക്കാതെ, പ്രീമെഡിറ്റേഷൻ, മുൻകൂട്ടി ഇത് പ്ലാൻ ചെയ്തതല്ല, പ്രീമെഡിറ്റേഷൻ, വിത്തൗട്ട് എനി പ്രീമെഡിറ്റേഷൻ, the accused number 1 assaulted the deceased. He would therefore submit that this is a case where exception 4 of section 300 of Indian Penal Code will apply, and thus it will amount to an offence under part 1 of section 304 of IPC. He relied upon various decisions of the Honorable Supreme Court of this court in the cases of Guru Sevak Singh versus Union of India, and another Ram Manohar Singh versus the State of Uttar Pradesh.